against Knight's solicitors and to attempt to disguise what had actually happened and quote a contract specification they had failed to follow in the other cases but insisted on using against my constituent. Mr Majid suffered compared to his contemporaries. LSC then told the PHSO that Mr Majid knew about the investigation into Knights, which wasn't true, and deliberately sought to avoid explaining that they were responsible for sitting on FOI requests which would have confirmed the basis of his complaints. They have also behaved appallingly in the way they have handled the Sajjad Ahmed Khan fraud and give no confidence that they are fit to discharge their public duties. I would appreciate anything the Minister might be able to do to recognise how much my constituent has suffered and that he does deserve to be compensated. And I'd welcome a thorough investigation into this agency. I believe there is a precedent for a judicial review in a similar case, because I believe there are too many people gaining from the public purse who are not doing the job we're paying them for. Someone is getting away with a cover-up, and it's plain wrong, Mr Sheridan.
Sheridan, I'm grateful to the Honourable Member for calling this debate, and I appreciate the passion with which he presented his case, and also I should put on record my appreciation for the information he sent me before this debate so that I could look at the points he was proposing to make. I should say at the outset I'll make some general remarks and then move on to some of the specifics that he brought up. But I do note that an entirely independent body like the Parliamentary Ombudsman, the PHSO, has rejected Mr Majid's case. I hear what he says in criticism of that body, but it is worth noting that that is a body entirely independent of the LSC or of government more widely. Obviously, I've listened very carefully to what he said. I hope he would agree with me that we should be very proud of our legal system. It's a valuable contributor to our society, and the government recognises that legal aid is a vital component of that legal system. And I'm well aware within that of the important role which duty solicitors, like the Honourable Gentleman's constituent, play in the criminal justice system. I've always made clear that defence lawyers are central to the criminal justice system. Throughout this year, I've been taking their views on how to make the system more efficient and what we can do to help them work more efficiently. Today, we have around 6,500 duty solicitors, qualified professionals who can offer advice and assistance to those without a lawyer of their own who are being questioned by the police or who are facing charges before the courts. This system ensures that all eligible people have access to legal advice from a suitably qualified legal representative, and the role they play is crucial to ensuring a criminal justice system that can operate efficiently. Last year alone, there were 734,000 acts of assistance to people being questioned by the police at a cost of £160 million to the taxpayer, and a similar scheme for solicitors in the magistrates' court operates at a cost of almost £22 million, providing help to individuals in courts across England and Wales. The Legal Aid Agency, which, as he correctly says, is what the Legal Services Commission has now become, has a statutory responsibility to run and maintain both the police station and magistrates' court duty solicitor schemes in England and Wales. It does this by entering into contracts with firms of solicitors, and the last tender process was for the 2010 standard crime contract, with contracts starting on the 14th of July 2010. The case made by the Honourable Gentleman is that his constituent raised a concern with him about how the then LSC has dealt with his complaint regarding the allocation of duty solicitor slots in the summer of 2010. And I can appreciate from his contribution that the period in question and the period since has been an extremely distressing time for his constituent. I think what I can usefully do is explain a little more about how the process works so that we can understand more about how the issue arose in the first place. The first point to be clear on, and this directly addresses one of the points he made, is that contracts are not awarded to individual duty solicitors. Contracts are awarded to legal aid firms. The proportion of slots that each organisation receives is determined by the number of duty solicitors that they've registered with the LAA, formerly the LSC. The allocation of slots is typically refreshed every 6 months, whereby organisations are required to submit the necessary forms to demonstrate how many duty solicitors they employ. A deadline is set to ensure fair and equal treatment for all of the firms involved. Yeah, of course.
Does the Minister think it was just bad luck that of those 14 people I referred to, that there was no effort to implement that part of the contract in relation to those who were granted the exemption before the termination of night solicitors and those afterwards? Or does he recognise that my constituent has clearly been dealt with differently from the other 14 people?
Well, I heard what he said, and as I said, he kindly gave me advance notice of some of it, so I happily guarantee to him I'll go away and look at some of the details. But as I say, I think there are some details that it's worth setting on the record, which I can do now. I talked about slot allocation, the deadline, and there are two advantages to this approach to slot allocation. Firstly, it ensures that firms have 6 months of stability of duty solicitor slots, enabling them to plan their workloads. And secondly, it provides administrative benefits to the LSC, as rotas are issued at fixed points without the need for many amendments. This is essential given the scale of the task in assembling these rotas. There are over 250 individual schemes with almost 800 rotas generated at each point. In the example today of the Honourable Gentleman's constituent, there was a deadline for all firms to submit their list of duty solicitors by the 14th of May 2010. It wouldn't have been possible to accept new submissions in June of 2010 without treating firms differently in the tendering process. Owing to the finite number of slots available, late additions would affect the allocation set for all firms who work on these schemes, and no other firm was requesting an extension to the May deadline. If a firm wishes to challenge their duty slot allocation, there are options available to them to appeal under the terms of their contract. However, the approach to slot allocation has been the subject of attention during 2013 as part of the debates that have been taking place following the publication in April of the government's proposals to transform legal aid. These proposals have had a focus on criminal legal aid, which accounts for about £1 billion of the overall legal aid budget, which, as he says, is just under £2 billion. Obviously, no sensible government can overlook such a sizable portion of government spending, and that's why we've embarked on the proposals to transform legal aid to deliver a more credible and efficient system. And the Law Society, as part of their response to the consultation, have highlighted some inefficiencies within the current system. In particular, they focused on the precise issue that the Honourable Gentleman has introduced today, that of the duty work allocation methods. And the Law Society has described the current approach to slot allocation as inefficient. In their response to the consultation, they described the incentive that firms have to employ more and more duty solicitors to gain more slots, even though the total size of the market is declining. This is not, I'm sure he'd recognise, a sustainable approach. They've also highlighted a practice they call ghost solicitors, which refers to solicitors having minimal links to a firm, receiving a payment that is neither a salary or linked to work done for the firm. And the Law Society itself is calling for a new method that no longer allocates work to firms on the basis of the number of duty solicitors employed. And the government has been working with the Law Society to explore these proposals alongside our consideration of all the other responses that we've received to the consultation. So there is a real general issue here, as well as I appreciate most of his speech was about the specific things that his constituent suffered, but I think it's worth putting that in context. If I can deal briefly with some of the individual points he made, though as I say, I will take away these points and look at them. He made the point that the LSC approved Mr Majid's application to work as a freelance duty solicitor through Knight's solicitors, and on the 7th of May approved his electronic registration for CDS 12. He didn't personally make an application to the LSC to work as a freelance duty solicitor for Knights. The LSC only accepts applications from firms, and they're required to declare that the solicitors are employed by them. So I think it can't be said that the LSE approved of any specific employment arrangement between Mr Majid and Knights in May 2010. He also said that the LSE negligently registered him with a firm which was under investigation for fraud and withheld that information. Again, I have to be clear, it's the firms themselves who submit their own list of duty solicitors. The LSE simply received this application in May 2010. And I should be clear on the allegation of withholding information. This was a police investigation, so the LSE were not acting inappropriately in the way they acted at that time. He also said that the LSE has behaved appallingly in the way they've handled the fraud, what he described in his speech, and therefore give no confidence that they're fit to discharge their public duties. It's fair to say the LSE acted promptly on concerns of Knights breaching their contractual duties, and this led to the termination of the contract. And the LSE, of course, the LAA as it now is always there to act to protect taxpayers' money, quite rightly. He also made some remarks about the PHSO, and experience tells us that actually the Parliamentary and Health Service Ombudsman always act robustly with organisations like the LSC, and on this occasion they did mount a full investigation. It was completed without any further action being required, and we have all been in a situation where our constituents have gone to the Parliamentary Ombudsman and have not had the result that they required. And I've heard what the Honourable Gentleman has to say about the PHSO, but I can only repeat that we all know that sometimes they come up with a result we regard as satisfactory and sometimes they don't, but they are entirely independent. They are designed precisely to be a court of appeal outside governmental structures, so that people can have some confidence that they're getting an independent response. And that's what they did in this particular case. And in conclusion, I should make it clear that... John.
Would you be willing to have a further meeting with me so that we can discuss some of the other aspects of this case that I don't feel have been aired so far today?
I suspect, and I'll happily discuss this with him afterwards, that the most useful meeting he could have would be with Matthew Coates, who's a new chief executive of what is now a new organisation, and I think he might find that a better way to take his case forward. So if he is happy with that suggestion, I can only repeat I'm grateful to him for giving us the opportunity to discuss what's clearly a vital issue to his constituent and an important issue to him.